at it.
So, well, for today, I have a new topic. We also have a listening activity. It's so sad that in the tools examination, listening is no longer a requirement. It makes me really, it makes me sad. I hope my efforts here aren't useless. That's my concern.
Yes.
Right. So, wow, is it 11th of November? Whoa.
Yes.
Right.
And in the next tools session will be dealt with on the 24th. So it's 13 days for the tools exam. I'm so proud of them. And of you, Rami, because you are going to sit for it also. Okay.
Right. So, well, today we're going to start with a second part for our understanding of contracts. Wow, understanding of contract.
Yes, a question, Tomás. This is the 10th unit, isn't it?
Yes, it's the final one. It's all that I have.
Okay.
Although, Romina, we have many times I have included tools examination activities, so we have been practicing a little bit.
Yes.
Okay.
A little bit, just a little bit. Very good. So let's move on. I just stated the date is today's the 11th of November. It's always a good idea to state the date in its recording.
Okay.
So now, risk, right there. Romina, can you read?
Yes. In a contract for the sale of goods, the parties usually agree which of them will carry the risk of the goods being lost or damaged before delivery.
All right, so now tell me, what does it mean, the risk of goods?
El riesgo.
Yes, it would, well, sorry. In other words, it means the parties have liability in that situation. Well, that was supposed to be the answer. Good, let's move on. So now we stated that the risk is who carries the liability in case the goods are damaged or lost. Who has it? So I actually didn't know that.
Hola, María.
So it's a new topic for me. Very good. So Maria, can you read?
Yes, where it is important.
It is important to be sure, yes.
Okay, very good. It is important to be sure who has liability because this can affect what insurance each party needs. Insurance each party needs to take out.
Right. Romina, can you read?
Yes. Who takes the risk if the product has been damaged before delivery?
All right, so both of you tell me who takes the risk if the product has been damaged before delivery. We're talking about risk, Maria.
If the delivery
in Argentina or for them?
¿Cómo?
In Argentina or for the Anglo-Saxon systems is your question?
Maybe, well, in our country.
No country.
I'm not so sure about the Anglo-Saxon system.
Yes.
That's why I'm asking you.
In our country, before delivery, you have several days to prove the product, to use it, and if it's damaged, you might request for o que te devuelvan el dinero, digamos.
For a refund.
The
refund. Reimbursement. That's the most formal expression.
A refund.
Igual creo que depende, porque esto dice que es antes de la entrega y hay cosas que de las cuales...
Before delivery.
Yes, before delivery.
Tal vez es un transporte, la empresa de transporte, tal vez no se hace cargo el vendedor, no sé. Habría que ver el caso.
Well, so the problem is here, the key is that all of this is before delivery, and after delivery, I think it's rather obvious who carries the risk. And so let's move on to a more happy topic. Wow.
Yes.
Title. Maria, sorry, is there anyone else?
No,
Because
Maria and Romy.
and Romy, right. Maria, can you read?
Yes, title means ownership of the goods or products. Lawyers often refer to having ownership of having as of something, as having title to the products.
How do we call having title in our legal system?
Ser titular. ¿O no?
Yes. Well, I was hoping for a more
Propiedad.
A more profound definition, more complex one, but if you say titular,
Propiedad.
property, it could be. But what I mean is the idea of having the possession of something. Do we have a special expression as in having title to? Because for example, here it says it's not title of the product, it's title to.
Title to the product.
Interesting. That's new for me.
Yes.
Right. So, Romina, can you read the next one?
Yes. Lawyers also refer to having ownership of something as having property in the product.
Property in the products. A new one for me as well. Property in.
Title to and property in.
Property in. Do we call it as what? Do we call it as well as having property in something?
No, I think we don't.
Or just having title.
Don't express in this way.
Very
we
good.
Say, having the property of the product, we say in
property
Spanish.
Of the product. Yes.
But in this case, it's property in the product.
In the product. All right. So the main difference here is my favorite thing, which is the preposition. That's why we study that a lot.
Yes.
So that you can realize how important it is and see the difference.
Yes, indeed.
Yes. So you will remember me and say, wow, Tomás was right all along. I hope you do.
The old cherished Tomás.
Right. All hail, Tommy. Right. Maria, can you read the next one?
Maria, are you there? Well, just in case, Romy, then.
Yes. Title is important because when you are the buyer of the product, you need to be certain about when the title passes from the seller to you.
Okay.
Seller to you. That's why we all need to be sure about our title. All right. So Maria can.
Yes.
We're still going on with title. Don't worry, Maria. Can you read the next one?
Okay. Perhaps as the buyer, you want to sell the product to a third party. At what point do you have the right to do so?
All right. So both of you tell me, at what point do you have the right to sell the product to a third party?
Tell us.
I don't know.
Oh, okay.
To sell the product.
Right. So, well, maybe it was.
You have the right to do so.
So you can sell the product to a third party, regardless of whether you can prove that you have property to the product.
Yes, maybe.
Well, if you say so, it's all right.
Yes.
I'll take your word for it.
Yes.
Romina, can you read the next one?
Perhaps if you are the seller, you want to retain title until you have been paid.
Okay, very good. So here comes a special clause in a contract that states who retains the title until the seller has been paid in full. Can you name Can any one of you tell me the name of the clause?
The
Retention of title.
yes, retention
Retention of
title.
title
Yes, yes.
for ROT clause. Maria, can you read?
Yes, the clause that deals with title in a contract is often called a retention of title or ROT clause.
ROT clause. Romy, can you read the final part?
It is a clause that says that ownership of a product remains with the seller until the buyer has paid in full.
Interesting. How do we call it in our legal system? Do we have a special clause?
It doesn't exist.
No, it doesn't exist. Interesting. But don't we have a special clause in a contract
No.
saying retención de
No, no.
No,
control de título o titularidad?
The institution doesn't exist.
Oh, interesting.
No, interesting. Yes, because if not, it would be terrible for us because it belongs to another mindset, the Anglo-Saxon mindset, not us. I think.
So how can we establish when the buyer has paid in full to the seller in order to transfer ownership? Because sometimes it says here that the seller may want to retain title until he has been paid.
When the good
In the
is
Spanish
delivered,
legal system in Argentine, how can we guarantee that the seller is going to be paid while the buyer he's in possession of the product?
because you have legal action and you may go for the payment through the courts.
Right,
That's
so
the way. Okay,
through legal action. Very good, interesting. Continue.
yes.
It looks, whoa, it sounds so risky.
Risky, yes.
Truly
But for them,
risky.
it's not risky because they are full of money.
Who? Who is
The
full of money?
companies have money, more money
Ah,
than the consumer.
yes. Interesting. I didn't know you didn't have a guarantee that the buyer is going to pay.
Well, it depends, but not this type of guarantee.
Interesting. I didn't know.
Okay, go on.
Very good. Okay, so I think that's the final part. So,
Okay.
well, I hope you enjoyed the topic because I loved it. It was new for me.
Okay.
So, very good. So how can I do it? No.
What?
Yes. Let me just show this. Wow. I'm still getting used to Zoom. Interesting. Give me a second. Whoa, it's so quiet. Right, so do you see this?
Guide? Yes.
Guide 17. Wow. My God, has it been 17 guides?
Yes.
I'm not sure. Why am I the only one surprised?
Go on, please.
Sorry, is that I always get surprised every time. Right, so we have a cool fill in the gaps activity right here. Okay. Do you want...
Tomás, are you recording?
Yes, it's recording.
Okay. Okay.
Yeah, it's recording. Don't give me, don't scare me.
Okay.
I feel bad. Right, so tell me whether you want me to share it with you.
Now.
We'll do it although. Right, so Romina, can you read the assignments of the first exercise?
Yes. Read following text about using a retention of title clause in a contract. Fill the gaps in the text with the correct word from the box below.
Right, so we're gonna start reading. Maria, can you read all of the words?
Maria, are you there? You know that, Romy, that Maria has
Yes,
some
yes,
problem
yes.
with some
No,
members of the
I'm
family.
moving to my house. So I'm traveling, but
Okay,
I'm here now.
okay.
Oh no, be careful. Be careful. Don't drive and talk to
No,
us.
I'm not driving. I'm not driving.
Okay.
Okay. Property, particular,
Yes.
retains, protect, debtor, premises, sale and installments.
Maria, let me stop you right there. Protect.
Yes.
Protect.
Protect.
No, protect. Doesn't exist.
Okay,
Protect.
sorry.
Go on.
Me?
Yes.
But I read it off.
Okay.
All right. Sorry, I couldn't read, and so I couldn't listen to you. Very good. So we have premises, sale, installment, protect, particular. Right, Romina, can you start reading? We're gonna read a little bit, and then we're going to start trying to fill in the gaps one at a time.
Okay. In most contracts for the sale of goods or products,
Sale of goods or products, yes.
it's a good idea to include a retention of title clause.
Mhm.
This clause is intended to protect
Protect, yes.
the seller from a buyer who does not pay for the goods or only pays in part. The clause will state that the goods remain the
No, Romy, let me stop you right there. Maria, can you go on reading right here from the clause?
Yes. From where? The clause?
Right here, the
will
clause.
state- yes, the clause will state that the goods remain there. I don't know, of seller until the buyer has actually paid for them.
Well, in this case,
Property, no. Remain
I think
the property of the seller until the buyer has actually paid for them. If the buyer does not pay for the goods, he or she is a debtor, which is a person who owes money to someone.
well, I had another word entirely in my mind.
Yes.
Right, debtor, yes. Debtor, yes, which is a person who owes money to someone. Go on, Romina.
A retention of title clause will also usually give the seller the right to enter onto the debtor's
Think of something in plural.
premises. And take back goods that have been delivered but not paid for. However, sometimes a particular difficulty arises in this situation. What happens if the debtor was paying for the goods in installments?
Installments, very good.
Let's say that debtor has paid.
Whoa, stop, please, Romina. Go on, Maria.
Okay, let's say the debtor has paid half of the total price of the goods and insists that he or she therefore has a legal right to keep half of the goods. The answer for the seller is to include that what is called on all monies provision provision in the contract of sale. This is a provision which states that until a buyer has paid everything that he or she owes to the seller, then the seller, ownership of all retains ownership
very good.
of all of his or her goods in the buyer's possession. This means that the seller can take back goods even in cases where the buyer claims that he or she has paid for those particular goods.
Particular good. Very good.
Okay.
So we also have another clause called all monies in our contract system, or not at all.
Todos los fondos.
All monies provision.
I don't know. No, not exactly this kind of provision.
Right. So,
Remember that in our system, they don't name the clauses as they do in the Anglo-Saxon system, because the Anglo-Saxons entitle every clause, but we don't put a title for every clause.
and so how do you differentiate between parts of a contract?
Parts of the parties, you say. The different parts go artículo 1, artículo 2, artículo 3, but they don't have a title.
They don't have a title. Very good.
Okay.
Right. So, well, that was the first part. In this case, we're going to talk about, Romy, can you read the assignment again?
Yes. The clause below deals with both risk and title. The clause is from a contract between a printing company and a publishing company. In this case, the goods mentioned in the contract are books. Decide whether the statements that follow the clause are true or false.
Very good. Maria, read all of the clause.
Okay, the property and risk in the goods shall pass from the seller to the buyer upon delivery, where all or part of the goods are retained by the seller, but the buyer has paid the agreed price. The property in such goods shall pass to the buyer upon payment, but the risk in such goods shall remain with the seller until delivery takes place.
Whoa, that's a lot of jibber jabber.
Like jibber jabber. And jibber jabber, that's a good expression. A jibber jabber.
Hi.
Jibber jabber.
Hi.
Hello, Tatiana.
Hello, Tatiana. Hello, Ignacio.
Hello, Juan Ignacio.
Also.
Hello. Hello.
We always need more people.
Well, go on, please.
All right, things that I'm not so sure how to proceed now.
Okay.
Romina, can you read here the phrases, and so we can start telling whether it's true or false?
Yes. When books that the buyer has paid for are delivered to the buyer, he or she then becomes the legal owner of those books.
Is it true or false?
True.
The dogs will answer.
I think it's true.
True. Yes.
Yes, true.
Okay. Okay.
True, yes. Tatiana, can you read letter B right here?
Yes. If books that the buyer has not paid for yet are mistakenly delivered to the buyer, the risk for those books stays with the seller. I think true.
Yes, it's true. And right, so Juan Ignacio, can you read? Let's see it right here.
Yes, if the buyer has paid for books, but the books are kept at the seller's warehouse until they are needed, the buyer has the risk.
Okay.
What do you think?
What do you think?
I think no, it's false.
Yeah, sadly, logic dictates that if all of them are true, one has to be false. Yes,
Uh-huh. Why?
that's good for an examination. All of you, you should know that. If all of
Right.
them are true, then it means that something we are doing is wrong. Right. So, Juan Ignacio and Tatiana, do you want me to share this with you so that you can look in, so you can take a look at it,
And take a picture.
or take a picture,
Okay.
or maybe you have already downloaded it. Right. So,
There it is.
Okay.
right. Oh, yes. Just. Oh. Right. Okay. So here, Romina, can you or Maria, can you read the assignment? Please, all of you, turn on your
Yes.
camera so that I know you're still there.
Okay.
Very
Can you
good.
send the link for the?
It's already
file?
sent.
No, I don't have it. Okay.
Very good. So, Maria, can you read the assignment right there? This is my favorite part.
Okay, look at the following clause. Complete the clause with the prepositions from the blue box.
Right. So, read all the prepositions right there for
Okay,
the word,
of,
right, for the phrase right here.
of, in, until, to.
Right. Tatiana, can you read all of it? And then we're gonna start, well, sorry, can you start reading, and then we're gonna start filling in the gaps right there.
Yes, property, the goods shall not pass the buyer. Payment is made by the buyer to the company, the agreed price. By payment.
Sorry, can you repeat?
I'm
I'm a little bit lost.
thinking.
Well, don't worry. It was just reading a little bit, and then we were going to stop at each of them so we can take a look at it more in detail. So we said property, the goods. What do you think? What did I just teach you? The thing is that Tatiana and Juan Ignacio didn't attend the first part of the lesson. Girls, can you tell them?
In, property in.
In or?
Property in the goods. Or title to.
Property in the goods, yes.
Pass.
Shall not pass. Who can give the answer right here?
Shall not
I
pass.
think it's property to the goods.
Property to the goods. Shall not.
Well, the things that property in the goods and to the goods is actually correct.
No,
But the
but the
things
thing
that,
is that Then you have shall not pass on the buyer.
To the buyer.
Yes,
buyer.
that's the point. To the buyer. So
Or of the goods, property of the goods. In the goods, no me suena.
But we just studied that it's called
yes,
property in the goods.
Yes, we
Yes.
studied. Yes,
Ella
yes.
no estaba. No aparece todavía.
No,
Okay.
Maria was
Ah,
during the first part of the lesson. I presented the topic right here. Tatiana and Juan Ignacio, we're discussing title and risk. Title and risk, right there. We were discussing expressions such as having property in the goods and property to the goods.
Then you will have another problem with is made by the buyer to the company, the agreed price. Sorry.
ahí
What
es.
goes there? In the agreed price. So in goes in D.
Of the agreed.
So it's property of the goods, I think.
Of the goods.
Mhm.
But
Because
I think, but
need
it's
an in.
wrong. My
Don't you
God,
have
it's
the-
wrong. Why?
Tomás, don't you have the keys, please?
I could,
Until
but it would take
payment is until payment.
Until payment.
Until payment
yes,
is
until
Is
payment.
made
till payment, yes.
by the
I
buyer.
could, but it could
to the
take me a
company.
while,
Yes, yes.
unless you want to wait.
No, yes, we wait for you.
Well, and so it's gonna take a lot.
Maybe it's off the agreed price and it's okay, the property in the goods.
Hey, we will see the keys, and that's it.
Okay.
Don't worry.
Hmm. You should know that the keys are always on the classroom
Yes, yes, we know.
for you to, oh, where is it?
There are keys.
Those are the keys right
Yes.
there. Can you tell me where is it? We're supposed to work with 10B, so let's
the
move on
10th.
to 10B.
Yes.
4A. Well, it's so long.
10B. B. Unit 8, unit 10A, 10B. Yes. So.
Where is it? 10B, so closing the contract.
Into until of. Let's see. Take a picture.
Okay.
Into until of. Take a picture of the second one, please.
No, wait. No, so because you're ruining the activity.
Yes, we're spoiling.
You're spoiling hours of work. Be patient, people. I told you, you can look for it at home. We come
Okay.
with a cup of coffee and the keys that it took me a lot to find and upload. Right, so we said can you repeat? We said of the goods shall not pass to the buyer until the payment has been paid to the company in the agreed price.
Yes.
I think it should be
No,
on.
the first one was in. Who remembers the keys, please? Anyone?
Mm.
Yes, in, to, until, of.
Okay. Let's read
Well,
it
so I
correctly.
was right all along. Wow.
Wow. Well, let's read the correct form. Please. Can we?
No, why?
read it along with the keys, please.
Right. This is the correct form. I just read the keys, and so this is correct.
Okay.
So let's move on to the next one.
But I would like to read it correctly, so it records in our ears. So property in the goods shall not pass to the buyer. Pass to the buyer was the secure answer. Until payment is made, that was also very good, very secure, by the buyer to the company of the agreed price. So
That's why in the agreed price, well,
Okay.
I thought it was so weird.
Okay.
Right.
Okay.
Very
Right.
good.
Go for the second one, please.
Juan Ignacio, can you read the assignments right here?
Yes. Look at the following clause. Complete the clause with the prepositions from the blue box.
Well, this is the blue box, don't worry. Read all the prepositions.
At, of, with, in.
In, right. So Tatiana, no, not Tatiana. Romina, can you start reading right here? And then we're gonna start filling in the gaps. Let's hope you don't get impatient.
No.
Property in the goods remains the company all times in the case of a hire agreement and until payment is made full in the case of sale
It's so easy.
Ese último of
Okay. Last one.
Obviously, come on, man. The exercise is spelling it out for you. Which is the answer? Remains
With?
with the company. Very good.
with the company
The company, obviously,
at all
times. Yes.
Okay.
You should. I told you, always look for these kind of collocations in examinations at all times. This is a
Okay.
classic collocation.
Okay.
in
In the case of a hire agreement, until payment is made, obviously, come on, in full. In the case of sale
of the good.
Of the
of the goods, yes.
Very good.
You see, in this case, it is of the goods. In this case, it was in the goods, and in this case, it's of the goods.
Okay.
Right. So we have Adela. You were going to explain afterwards some things about the examination, right?
Yes. Yes. About TOEFL exam particularly for Juan Ignacio. I will provide
Interesting.
him with a format. I'm searching for it. But it's for him, only for him, and for the other girl that's not present.
Because we have just one final listening activity.
Okay, go on, please.
That it's rather long, but
Okay.
my main concern is time.
Okay.
Right. So Tatiana, can you read Maria, can you read the assignment?
Yes.
Do you see it? It's on frame number 5.
Yes. Exercise 3. A lawyer is speaking to a group of trainee solicitors who are starting their work experience in her department. Some of the goods are missing. Listen carefully and fill in the missing words. Write your answers in the box below. I'm sorry.
Yes. Yeah, don't worry. Write your answers on the box below. And well, now we're going to listen to the girl. Unless you want to read a little bit about it first, or you just want to listen in from her, because the answers are, the gaps are actually in frame number 6.
Well, but the thing is that
part,
they may take a picture of this part.
obviously.
Yes.
Although this part isn't actually important, but you can do it, yes.
It's introduction.
This introduction, yes. So that you can have a more profound development of the character.
Okay.
Right, so do you want to read a little bit about it, or you just want to hear it from the girl who's gonna talk?
No, go on with the next.
With the listening.
Yes.
Okay.
Sorry, do you want to
Take
take a picture of all of them, because it's
yes.
rather long. It's
Oh, another one.
4 frames long. Right.
And try to take notes while you listen to it.
Right, so shall I play it?
Yes.
Okay.
It's so silent.
Is that okay?
Okay.
Right. Tell me whether you can listen to it.
Exam exercise listening.
Hello and welcome to
Can you
Yes.
listen to it?
Yes.
Yes.
It's so that I don't have to change the tab shared. All right, so let's start again. And don't worry, because for the first part, you will only listen to the one on frame number 5.
Exam exercise listening.
Hello and welcome to the Banking and Insolvency Department. My name is Kim Watts and I'm very pleased to meet you all. This is quite a large department, doing a lot of varied work. I specialise in insolvency. Most of our clients are either banks or companies. The banks have generally made a large loan to a company, often secured by a debenture, and now the company is failing to make its repayments on the loan because it is in financial difficulties. The bank instructs us to assist with the recovery of the debt. Our other clients represent the other side of the coin. They are companies who are facing insolvency, and they come to us for advice on the best way forward. The most common description of insolvency is that a company cannot pay its debts when they become due. There are various insolvency procedures that are available to companies. I'd like now to briefly outline these procedures, as they often cause confusion until you become more familiar with them. First is the compulsory liquidation of a company. This is when the court orders the company to be wound up. Winding up usually starts by a creditor making a petition on the grounds that the company cannot pay its debts. The official receiver, who is an officer of the court, becomes the liquidator of the company, and he or she has a duty to investigate the company's affairs and the causes of its failure, including the conduct of the directors. A director can be disqualified from acting as a director for a period of time if, for example, he or she made the position of the creditors worse by continuing to trade when the company was insolvent. When the winding up is complete, the company is formally dissolved and it no longer exists. Next is administration. This is a court order made to appoint an administrator to manage the company's affairs. A court may make an administration order when the company is unable to pay its debts, and the court considers that by making an administration order, the whole or part of the company may be saved as a going concern. The company, its directors, or its creditors start the procedure by making a petition against the company. While an administration order is in force, the company cannot be wound up, and legal proceedings against the company cannot be started except with the approval of the court. The administrator takes control of all the property of the company and makes proposals for the creditors to consider. The administration order continues until the court decides that the order is no longer needed and formally discharges it. Another insolvency procedure is receivership or administrative receivership. A receiver is appointed by the holder of a debenture of the company secured by a floating charge. Usually this is a bank. The company is said to be in receivership. The receiver has the power to sell the assets covered by the floating charge and give the proceeds to the charge holder. A further procedure is a company voluntary arrangement. We call this a CVA. This is when a company makes an agreement with its creditors in order to settle its debts over an agreed period of time. The agreement has to be approved by the court. Meetings of the company and creditors are called to approve the proposed arrangement. Once approved, all creditors who had notice of the meeting and were entitled to vote are bound by the terms of the arrangement. The company can continue trading during the CVA and afterwards. Finally, there are two types of voluntary liquidation. Members' voluntary liquidation means that the directors have made a statutory declaration of solvency. In other words, the directors believe that a company is solvent. This happens when a family business is sold off, for example, or if the purposes of the company have come to an end. The liquidation starts when the members, in a general meeting, pass a resolution to wind up the company voluntarily. Remember, if it is a voluntary liquidation, the company is not insolvent. In the case of a creditor's voluntary liquidation, the company cannot pay its debts. The process is started by the directors, not the creditors. The company carries an extraordinary resolution to say that it cannot continue in business because of its liabilities and that it is advisable to wind up. A liquidator is appointed to wind up the company's affairs. The liquidator does this by realizing the company's assets and paying its creditors. If anything is left over, the members of the company receive it. In both types of voluntary liquidation, when the company's affairs are fully wound up, the formal dissolution of the company occurs and it ceases to exist. Well, I hope that this helps just a little. I am sure that you will gain some experience of all these procedures during your 6-month period with this department. We have a great team here and everyone will be very happy to answer any questions you have, so please feel free to come to any of us at any time.
All right, so shall we listen to it again? Sorry, who has been touching the frames?
Sorry,
Don't do that because I need the number of frames in order to arrange my mind. Wow.
Okay,
Yes.
not that bad.
Because with the number of frames, you know the number of activities you have. Most of the time. Right, so do you want to listen to it again?
Yes,
okay.
some words I didn't understand.
Right, so we'll listen to it again. Are you ready?
Yes.
Very good.
Okay.
I didn't think it was so hard. The lady spoke a lot, but it wasn't so hard.
Exam exercise listening.
Hello and welcome to the Banking and Insolvency Department. My name is Kim Watts and I'm very pleased to meet you all. This is quite a large department, doing a lot of varied work. I specialise in insolvency. Most of our clients are either banks or companies. The banks have generally made a large loan to a company, often secured by a debenture, and now the company is failing to make its repayments on the loan because it is in financial difficulties. The bank instructs us to assist with the recovery of the debt. Our other clients represent the other side of the coin. They are companies who are facing insolvency, and they come to us for advice on the best way forward. The most common description of insolvency is that a company cannot pay its debts when they become due. There are various insolvency procedures that are available to companies. I'd like now to briefly outline these procedures, as they often cause confusion until you become more familiar with them. First is the compulsory liquidation of a company. This is when the court orders the company to be wound up. Winding up usually starts by a creditor making a petition on the grounds that the company cannot pay its debts. The official receiver, who is an officer of the court, becomes the liquidator of the company, and he or she has a duty to investigate the company's affairs and the causes of its failure, including the conduct of the directors. A director can be disqualified from acting as a director for a period of time if, for example, he or she made the position of the creditors worse by continuing to trade when the company was insolvent. When the winding up is complete, the company is formally dissolved and it no longer exists. Next is administration. This is a court order made to appoint an administrator to manage the company's affairs. A court may make an administration order when the company is unable to pay its debts, and the court considers that by making an administration order, the whole or part of the company may be saved as a going concern. The company, its directors, or its creditors start the procedure by making a petition against the company. While an administration order is in force, the company cannot be wound up and legal proceedings against the company cannot be started except with the approval of the court. The administrator takes control of all the property of the company and makes proposals for the creditors to consider. The administration order continues until the court decides that the order is no longer needed and formally discharges it. Another insolvency procedure is receivership or administrative receivership. A receiver is appointed by the holder of a debenture of the company secured by a floating charge. Usually this is a bank. The company is said to be in receivership. The receiver has the power to sell the assets covered by the floating charge and give the proceeds to the charge holder. A further procedure is a company voluntary arrangement. We call this a CVA. This is when a company makes an agreement with its creditors in order to settle its debts over an agreed period of time. The agreement has to be approved by the court. Meetings of the company and creditors are called to approve the proposed arrangement. Once approved, all creditors who had notice of the meeting and were entitled to vote are bound by the terms of the arrangement. The company can continue trading during the CVA and afterwards. Finally, there are two types of voluntary liquidation. Members' voluntary liquidation means that the directors have made a statutory declaration of solvency. In other words, the directors believe that a company is solvent. This happens when a family business is sold off, for example, or if the purposes of the company have come to an end. The liquidation starts when the members, in a general meeting, pass a resolution to wind up the company voluntarily. Remember, if it is a voluntary liquidation, the company is not insolvent. In the case of a creditor's voluntary liquidation, the company cannot pay its debts. The process is started by the directors, not the creditors. The company carries an extraordinary resolution to say that it cannot continue in business because of its liabilities and that it is advisable to wind up. A liquidator is appointed to wind up the company's affairs. The liquidator does this by realizing the company's assets and paying its creditors. If anything is left over, the members of the company receive it. In both types of voluntary liquidation, when the company's affairs are fully wound up, the formal dissolution of the company occurs and it ceases to exist. Well, I hope that this helps just a little. I'm sure that you will gain some experience of all these procedures during your 6-month period.
Right, so were you able to fill in the gaps, some of the gaps? For example, she talks about now the company is failing to make its repayments on the loan because it is in financial
Difficulties.
Right.
Yes.
Okay.
The bank instructs us to assist with the recovery of the debts our clients represent. Very good. So first is a compulsory liquidation of the company. This is when the court orders the company to be wound up. Winding up usually starts by a creditor making a petition on the
Grounds.
Grounds.
Another collocation on the grounds
On the
that,
grounds that. Sobre la base de, on the grounds that.
yes, on the grounds that. That's why always remember collocations.
Yes.
Cannot pay its debts. Official. All right. So Maria, can you go on reading? It's a lot for me.
The official receiver, who is an officer of the court, becomes the liquidator of the company, and he or she has a duty to investigate the company's affairs and the causes of its failure, including the conduct of the directors. A director can be disqualified from acting as a director for a period of time. For example, he or she made the position of the creditors worse by continuing to trade when the company was insolvent. When the
yes.
winding up is complete, the company is formally dissolved
Dissolved.
and it
Yes.
no longer exists.
Right. Dissolved. Yes. Very good. So, Romina, can you go on reading with administration?
Next is administration. This is a court order made to appoint an administrator to manage the company's affairs.
Manage, yes.
A court may make an administration order when the company is unable to pay its debt and the court considers that by making an administration order, the whole or part of the company may be set as a going concern.
Concern, yes. Stop right there. Juan Ignacio, can you go on reading with the company?
Yes. The company, its directors, or its creditors start the procedure by making a petition against the company. While an administration order is in force, the company cannot be wound up and legal proceedings against the company cannot be started except with approval of the court. The administrator takes control of all the property of the company and makes proposals for the creditors to consider. The administration order continues until the court decides that the order is no longer needed and formally discharges it.
Very good. Tatiana, can you read the second part right here with another insolvency procedure?
Yes. Another insolvency procedure is receivership or receivership or administrative receivership. A receiver is appointed by the holder of a debenture of the company secured by a floating charge. Using this is a bank. The company is said to be in receivership. The receiver has power to sell the assets covered by the floating charge and gives the proceeds.
Very good. Yeah.
To the charge holder.
Wait right there. Proceeds to the charge holder. Very good. Who else is there? I need more people. Maria, can you go on reading?
Yes. A further procedure is a company voluntary arrangement. We call this CVA. This is when a company makes an agreement with its creditors in order to settle its debts over an agreed period of time. The arrangement has to be approved by the court. Meetings of the company and creditors are called to approve the proposed arrangement. Once approved, all creditors who had notice of the meeting and were entitled to vote are bound by the terms of the arrangement. The company can continue trading during the CVA and afterwards.
Wait right there. Romina, can you go on reading right here, finally?
Yes. Finally, there are two types of voluntary liquidation.
Voluntary.
Liquidation. Members' voluntary liquidation means that the directors have made a statutory declaration of solvency. In other words, the directors believe that the company is solvent. This happens when a family business is sold off, for example, or if the purposes of the company have come to an end. The liquidation starts when the members in a general meeting pass a resolution to wind up the company voluntarily. Remember, if it's a voluntary liquidation, the company is not insolvent.
Yes, start right there. Sorry, wait right there. Tatiana, can you go on reading right here in the case?
Yes. In the case of creditors' voluntary liquidation, the company cannot pay its debts. The process is started by the directors, not the creditors. The company carries an extraordinary resolution to say that it cannot continue in business because of its liabilities, and that it is advisable to wind up. A liquidator is appointed to wind up the company's affairs. The liquidator does this by realizing.
You know that realize is darse cuenta de algo, but in this case, realizing the company's assets is liquidating, selling.
Liquidating.
Yes.
Realizing
Realizing
the company's assets.
Be careful with the stress.
Realizing.
And be careful here with process. Process, it means it's a verb in conjugation, and process is the noun.
The process.
Yes, the process. So in a company, the members of the company receive it. Go on right here. Tatiana, finish the part right there.
Okay, the liquidator does this by realizing the company's assets and paying its creditors. If anything is left over, the members of the company receive it.
And never forget assets.
Assets.
Bienes, assets.
Right, Juan Ignacio, can you read it right here in both types?
Yes. In most types of voluntary liquidation, when the company's affairs are fully wound up, the formal dissolution of the company occurs. You say that like that, no? Occurs, and it ceases to exist.
Very good, ceases. I love that verb. To cease, ceases. Right, so, well, now, you know, let's hope that just a little bit, I'm sure that I will get some experience of the procedures. Now, I'm going to pass the floor to Adela.
Okay, okay. I have another activity, a little.
Sorry, shall I stop recording?
Stop and then restart, please.